Hi, my name is Joe Di Bartolomeo. I'm an Oregon personal injury lawyer. I have offices in Astoria, Oregon, and in Hillsboro, Oregon. And in today's video, I'm going to talk about 5 mistakes you can avoid when you have an Oregon personal injury claim. The reason I make this video is because people come in to see me after they've been injured in a claim, or after they've been injured. And it may be a car collision. It may be they were injured on somebody else's property. And some people come in a couple months after they were injured. Other people may try to handle the claim on their own. And for some reason, they decide that they want to get a lawyer involved. And I pick up the case and take a look at it. And I will see mistakes that they have made in their interaction with the insurance adjuster, or maybe in the way that they sought medical care, or some other mistake. And it's done and over with, and we do the best that we can. So I'm making this video to help you avoid making these mistakes. Some of them are not very harmful. Some of them can be. And I'm hoping that this video avoids or helps somebody avoid making these mistakes. So let's start out. We'll go through the list 1, 2, 3, 4, and 5, and we'll go that direction, and hopefully it'll provide you with some good information. There are a lot of myths and stereotypes about people who pursue personal injury claims. I deal with that all of the time. I've tried quite a few cases in front of juries, and I'm very open about talking about these stereotypes and myths that people are out to get something for nothing, that people are greedy, that they're fakers. And I'm not saying that there are people out there who try to game the system, but you and I may disagree about how often that happens and when. So one of the things that I more often see are people who end up being pretty darn seriously injured, but they decide that initially they're not injured and they're just going to power through it. I think that's a common trait for people who live in the Pacific Northwest. I think it's a common trait for people who work in my neck of the woods in Northwestern Oregon, because people who live out here they're tough people, and they deal with pain every day and in their work. And so they just try to power through it. Now, what tends to happen, though, is somebody gets injured, and most of the cases I work on involve people injured in auto collisions. Somebody gets hurt in an auto collision. They deny that they're injured to the police. They probably honestly think that they are not injured. They end up refusing an ambulance because who needs that? And they go on. And they may try to resume their normal activities. There may be some denial in that. And then it turns out later on that they have a pretty serious injury. It may be a torn ligament in their shoulder or their knee. There may be a serious back injury that ends up going to surgery. The mistake that I see people make is that they don't get checked out. Now, getting checked out just means that it may be that you're not that seriously injured. You may not have a serious problem that's life-changing or long-term. You may not need that much medical care to get back into the game, but it's a good idea to get checked out. I've talked with local insurance agents who sell insurance, who sell the product, and the ones that take good care of their customers and clients will say, after they get a report of an injury, will say, you know what, go get checked out, just make sure you're okay. So I think I've said it 50 times. I'll say it one more time. If you've been injured in an accident, go get checked out just to make sure that you're fine and that there's nothing really serious going on. So let's move on to the next mistake. So this is kind of going to try and handle 2 things at once here, but it's basically not reporting or filing the claim. And let me explain what I mean. Personal injury protection is an insurance benefit that you have if you're an Oregon motorist and you're insured in Oregon, that you have on your auto policy. It's no-fault medical insurance, and most people end up filing these applications if they've been injured in a collision. the thing to keep in mind is that it's a no-fault benefit, which means that you may have run into somebody or caused an accident, or you may have run into, God forbid, you run into a telephone pole or something like that. You're covered under your own policy. You should file the personal injury protection application. When you file that application, you will be asked to explain what happened, how the injury occurred. You will be asked to talk about what kind of injury you suffered, and you will be asked where you got your medical care and whether you were injured, whether you missed work. And so you want to file that claim. Now, a lot of folks who have a local insurance agent will contact their agent, and the agent will put them in touch with the claims person to get the application filed. And also, a lot of times this can happen online, and you can get that claim filed. And some of the larger insurance companies have really good online tools to help you with that process. Don't wait. File the personal injury protection claim. Now, if you have an injury that you're pursuing, you may have been injured on somebody else's property, and you have an injury claim, then the insurance company that you're going to notify would be your health plan. And health plans technically are not insurance companies, but that's just me being a lawyer. You want to notify your health plan. And the reason is that if your health plan is covering or providing coverage, paying your medical bills for your injury-related expenses, they have a provision in their document, their health plan, that will require you to reimburse them for the benefits they provided if you are able to make some kind of recovery against the at-fault party's insurance. And I have videos that talk about that in greater detail. I also have an Oregon personal injury guide that covers that. If you're watching this video on my website, you can find that guide up above. If you're watching this on my YouTube channel, that link is below. You can check that out. It doesn't cost anything. It's an ebook. You can download it. So you want to report to your health plan. A lot of times your health plan will contact you, and they will ask that you file or fill out a form. You need to fill those forms out, because if you don't, they may deny your medical coverage, and you don't need that headache. So fill out the form, let them know about it, and then they will be watching. And when the case gets ready, hopefully it resolves. But one way or another, if you're able to recover any compensation, you need to work with your health plan, getting them paid back, making arrangements for that to happen. So I think that was mistake number 2. So let's move on to the next most commonly made mistake that you can avoid when you have an injury claim in Oregon. That's kind of 2 mistakes in one, but I want to cover this because in many of the cases that I work on, my client, at the time they hire me, has done one or the other. They have signed medical authorizations for the other side, or they have given a statement to the insurance company for the other party, and we deal with that. And to be honest, many times giving a statement or providing a medical release or a medical authorization, it's not a death knell. It's not a fatal mistake. It can be, but oftentimes it is not. But when you are injured, especially in a car collision, you're going to get a call from the other driver's insurance company, the adjuster, and they're going to want to take a statement from you, and they're going to provide you or introduce it in a way that makes it sound like it's mandatory. Well, it's not. You do not have to give a statement to the other driver's insurance adjuster. You can refuse, and there's nothing that they can do about it. They can threaten that they will close the claims file. That doesn't mean anything. They can't close they can close the file. It doesn't mean anything. You can still make the claim. So the reason you don't want to give a statement is because you may make a mistake. These people are trained to get you to say things that they can use later on when you pursue your claim. So you don't have to give a statement. Don't feel that you must. As far as medical releases go, if you look at a medical authorization that this insurance adjuster will send you, it's very broad. It covers not just the accident-related medical records and bills, but any medical records or bills. And it also probably gives them the right to talk to your doctors. And I've not seen that happen. It probably has, but there is no reason that you need to give the other side of the claim carte blanche to your medical records or your doctors or your healthcare providers. So don't sign any medical authorizations. And if you have, you can write a note to the adjuster revoking the medical authorization. We do that in every case. When we write a letter telling the adjuster we represent an injured person, first thing we do is revoke all medical releases, and we ask for the medical records that have been obtained. So that's the mistake that I probably see the most often. But that being said, it probably isn't as harmful, at least most of the time, as some of the other mistakes that we've seen. So let's move on to the next mistake. When I am hired to represent somebody, I write a letter and I kind of give them a list of do's and don'ts. And one of the things that I talk about is posting details of the injury to social media. And a lot of people do that. A lot of people, will post facts about their injury event on their social media page. Sometimes people will say, be careful, look out for other drivers, or, I won't be able to make it to whatever. And they post to social media. But then some people post a lot of details about their injury or their activities after the injury onto social media. And that can be a problem later on, because the insurance company will look at your social media page. And if it's public, if your posts are public, and it's surprising how many people have social media pages where everything is public, they can take things out of context and use those social media posts against you to make it appear that you are not as injured as maybe you later claim. And so we always advise clients not to post details about the injury event or their injuries or their treatment or their recovery on social media, because it just muddies the water. And in a personal injury claim, you have the burden of proving that the other party was at fault, and you have the burden of proving how it affected you. And the insurance company and the other side of the case have no burden of proof. All they have to do is make things more confusing and get in the way of you proving your case. And exploiting social media posts is one of the ways that they can do that. So don't do it. If you want to communicate privately with somebody, go that route. Keep in mind, though, even those private communications may come up later on. So that's the caution against posting details about your claim on social media. All right, let's move on to the next one. So I kind of covered this when I talked about waiting too long to see the doctor. I kind of got into some detail about this, but I continue to be amazed at the people I represent who undertreat for the injuries that they suffer. Most people they're not into going to see the doctor if they can help it. And again, I understand that. If I have something else to do, I may skip out on making a physical therapy appointment or following up with my doctor. But the fact of the matter is that insurance companies, when they evaluate a claim to resolve it, even in it could be a very clear situation where their insured caused your injury. For example, you may be dealing with a situation where you were stopped at a stoplight, somebody runs into you at a high rate of speed, and you're injured, legitimately injured, and you need medical care. And you require maybe physical therapy. And physical therapy is one of those things, it's a commitment, because you have to do it often and maybe for a long time. I have seen people go to physical therapy after an injury for up to a year because it was a serious injury, there was surgery, and they have to rebuild that injured joint. So if you don't go, if you miss your appointments, then the insurance company is going to assume that you are not that seriously injured as you claim to be. And that makes it difficult. The other thing that's going on is that, and I posted a video on this topic, is that insurance companies have a completely different mindset than maybe you do in figuring out, well, what is fair and appropriate for compensation? And one of the things that the insurance companies do, actually probably most all of them do, is they use algorithms or computer software where they punch in information about your medical care to determine what they feel a fair offer is to make when negotiating your claim. Well, if you're missing appointments, that's a lack of medical evidence, and that's going to affect what the insurance adjuster is authorized to offer you to resolve your claim. And there have been many times I'm on the phone with an adjuster and we're arguing about what is fair, what is appropriate, or how much the claim should settle for. And I get an argument that my client didn't go to the doctor or didn't make physical therapy appointments, and the assumption is they must not have been all that badly injured. More important than that, though, is if you want to make a good recovery from your injury, you need to do what the doctor said. And there's a concept in law called mitigation. So if you have a serious injury and there's some permanent impairment, but you didn't do your physical therapy, you can expect somebody, it could be an adjuster, it could be a defense attorney, it could be a mediator, a judge, or a jury, to think about whether you actually did everything you could have to minimize the long-term consequences of your injury. So you need to go to the doctor when the doctor says you need to go. You need to go to your physical therapy when your doctor says you need to go. Don't be a hero, because at the end of the day, it'll probably hurt your claim. So I don't mean to sound like your dad, but sometimes that happens. So I hope this video was helpful. If you have other questions, you can contact us. I will leave a link below on the YouTube version of this, and above you will find my contact link on the website if that's where you're watching the video. If we're not able to help you, we often will find somebody who can, so don't hesitate to contact us. If we can give you information that sets you in the right direction, we will do that, so don't hesitate to contact us. Thank you so much for watching the video. I hope this was helpful. Take care.